so I guess we're ready to continue. So please proceed.
Thank you, Mr. President. Mr. Seda, can you please take your first witness statement, paragraph 62? This now is, we're in 2014, early 2014, and you describe here the first time that you hear from Mr. Ivan Lopez Venegas. So here, just to summarize, 62, you say that you received phone messages from an individual, Ivan Lopez Venegas, who claimed to be the rightful owner of the land on which the Meritage project was being built. On the same topic, I think, if you take now your second witness statement at paragraph 7, it's a long paragraph, so I will start with the second half. In the middle, starting with thus, so we're in the same period, we're in early 2014. So I quote, thus, when Lopez Venegas surfaced in 2014 with his claims to be the rightful owner of the Meritage property, I tried to assess what possible basis there could be for his claim because I had never heard his name before. He did not appear on the title study, and when I asked Juan Pablo Lopera, our in-house counsel, to conduct an internet search of Lopez Venegas' name, it revealed that he had previously been convicted of drug trafficking charges in the United States. This gave me further reason to dismiss his claims as they came from what I considered to be a highly discredited source. So, essentially, this is straightforward. So he says he's the rightful owner, right? This is what he says to you, and then you establish for yourself, this is your own due diligence, I assume, that he's a, convicted of drug trafficking, right? Drug trafficker, essentially. That's what you think at the time.
Just to add clarification, I never spoke directly to him. Mm-hmm. He called my offices, and he left messages with our secretary. Whether it was him or a representative of him, I can't tell you because I didn't talk to him. And regarding the diligence or, let's say, inquiries made, I asked our in-house counsel, Juan Pablo Lopera, to look at the documents and see if he was on title. He responded back to me that he wasn't. I asked him to look and find out. I didn't say, for example, do a Google search. I said, figure out who this guy is. And he says, well, this may be him. And there was an article, there were two articles. There was one article referencing that he had been extradited to the United States on drug charges. And then there was another article said he had been exonerated after the fact. Nonetheless, he seemed quite shady.
Right, but what you established for yourself at the time is that he's based on that search, is that he's a convicted drug trafficker, and then it's a highly discredited source. I'm just reading from your testimony.
Yes, I wasn't completely sure what to think or put together with the whole he was extradited and then exonerated. I wasn't sure what to think, but this wasn't the first extortion claim that we had received. In every project we receive at least, 5 to 10 extortion claims. Most very small, very silly things, run-of-the-mill things, and this just seemed like another one of those same old things.
Okay. So then, if we look at your first statement, if you can go back to it at paragraph 65.
I'm sorry, paragraph what?
65.
Thank you.
This is where you state that Mr. Lopez Vanegas went to see the president of Corfi Colombiana, right? We have that at the bottom of the page and top of the next page. That's what you discussed, I presume, with Corfi Colombiana. And you say, I quote, we discussed and agreed that Lopez Vanegas' claim had no merit, that did more than sufficient. Right, and then you say, for the time being.
For you. I think it's pretty clear that I'm talking about, when I say we, it's referring to Jaime Toro and myself.
Okay, so the president, right, of Corfi Colombiana.
Not of sorry for interrupting. Not of Corfi Colombiana, of the, at that time, I think he was the head of the real estate, what does it say here?
Right.
Real estate, national director for real estate for Corfi Colombiana.
Okay. So you decided to ignore, and that was it, right? That's the testimony in 2014.
No,
Actually, this is middle of 2015. I'm sorry if I look, if I want to get the dates right. So is it middle of 2015?
I believe so. That my recollection is more or less that.
Okay. We don't have a testimony from Corfi Colombiana in this case, do we? We don't know. I mean, we have to take your word for it, right?
You have to believe my testimony. I mean, I don't know if you reached out to Corfi Colombiana. I've spoken to them, and they stand by these statements as well.
Did you ask them to provide a testimony?
No, we didn't ask them. Well, that I know of, we didn't ask them to provide testimony.
Okay.
I know they were spoken to by. Well, I don't know if I'm supposed to even speak about attorney conversations.
Well, do not if it's attorney-client privilege. I don't want you to disclose anything.
Okay.
So now your second statement, paragraph 9.
Second statement.
Yes. So this is essentially the reactions after Lopez Vanegas contacts you, right? So here we have now La Palma. And you discuss here, no more, I quote, no more than 24 hours after Lopez Vanegas contacted Royal Realty, I also reached out to Fanny Giraldo, legal representative of La Palma. Giraldo informed me she had never heard of Lopez Vanegas before either. La Palma and as the land sellers looked into Lopez Vanegas after this, Giraldo told me that they had made inquiries with the Fiscalia, which informed them that Lopez Vanegas had approached them, but his claims were baseless and would not go any further, and that they were interested in bringing extortion charges against him in connection with the threats he was making. So again, just like for Corfi Colombiana, you discuss with Ms. Giraldo, and she says, not a problem. You should not be concerned about this, right?
So I contacted La Palma, considering they were the sellers who were conveying title to us. And as it says there in my witness statement, they said they had never heard of this individual before. They advised me that they were going to reach out to the Attorney General's office to make further inquiries. They did, and I believe there's a lot of stuff said about Mr. Lopez, that he was a criminal, that he had escaped the hands of Colombia, so on and so forth, and they said that they were looking to go against him. Yes.
So did you ask to see the response that the Fiscalia had provided to Ms. Geraldo?
My understanding is it was to have a conversation between their attorney and someone within the Attorney General's office.
You don't have any details on that. She just told you that you had spoken to someone at the Attorney General's office, right?
No, they didn't provide me with a letter or a written response of their oral communication with the Attorney General's office, no.
So you don't know if that was a formal request to Fiscalia or just an informal discussion with someone who's unnamed and we don't know who it is?
My understanding was that they went and spoke to someone at the Fiscalia, and this was the response that was given to them. I didn't ask what department, all the things that you're advising. This timeline happened very quickly, and very soon after that matter, I was on national radio providing all kinds of proofs of what we had done and addressing the entire world, let alone the Fiscalia.
That's not my question. My question is, when you discussed with Ms. Geraldo, what did you ask her? She told you that she had discussed with somebody at the Attorney General's office, but you don't know who, you don't know if it was formal or informal. We're in the world of hearsay now. We just don't know who and how and when, right?
That's correct. I do not know exactly who they spoke to, exactly what the conversation was. They gave me a summary of what they had spoken to their attorney about.
And you didn't ask Ms. Geraldo to give an affidavit in this case, did you?
I believe I spoke to her. I believe, again, I'm not a well-versed attorney. I don't know how to put this. Without breaking privilege, I believe my counsel spoke to her.
Okay. Let's leave it at that. Now, next paragraph, 10. Here you say, I'm quoting, I also disclosed the threats I had received from Lopez Vanegas to Corfi Colombiana. I further arranged meetings with all existing unit buyers in the Meritage property and gave them copies of the Otero and Palacio title study, that's what we discussed earlier, and the Fiscalia certification of no criminal activity. That is also what the document that we saw earlier, right? The 9 September 2013.
Sorry, one moment. One moment. Okay, just to put this in context, we were first talking about immediately hearing from Mr. Lopez. Then now we're talking about this between these two moments in time. There's a W radio interview. So just to give context. So
I'm just following what you're saying in your statement. So
Yeah.
you discussed in 9. You said that you discussed with Ms. Geraldo, and then you said that you discussed that with the buyers, right?
correct.
And that to give comfort to the buyers, you showed them the Otero in Palacio and the Fiscalia's response to the right of petition, right?
That's correct.
And then if we go back to paragraph 7, just the page before. So essentially, to summarize what we've seen before, you hear from Mr. Lopez Vanegas, you discuss with your in-house lawyer, he determines, based on what he can find, that he's a convicted drug trafficker, not exonerated, in fact, just for the record, the court found that they didn't have jurisdiction, but in the U.S., with charges in the U.S., so you talk to Corfi Colombiana, you talk to Giraldo, and you talk to the buyers, right? So that's what you do, following the charges, right? The contact by Lopez Vanegas.
Yes, and just to add context, I'm not saying that he was exonerated. I'm simply giving reference to an article that we found, which says that he was exonerated and or absolved. That's it.
Right.
But more or less the chronological order of what you just said sounds about right.
Okay, now let's look at paragraph 7. Now this time the top part of the paragraph. And here you respond to Colombia's counter memorial, and you say, I quote, "And no, I did not immediately report this to authorities in Colombia in 2014 for several reasons. As a developer," and that now is what you mentioned a bit earlier, I quote again, "As a developer in Colombia, it is a harsh reality that on every project you will receive extortion threats from opportunistic individuals, whether neighbors, city employees, state officials, who claim to have the power to interfere with your project. If you stopped every project because of these threats, you would never get anything built. If you paid every demand, you would never get anything built, as well as likely break the law. And the fact is that reporting such threats to authorities can often make things considerably worse, because public officials are involved in the threats in the first place, or may become so once they're reported. So the first course of action is almost never to report such demands to the authorities, but to reject such demands, and if the perpetrator will cease of his own accord." Right? So these are your reasons for not reaching out to the authorities in Colombia, right?
Correct.
So essentially, the course of action is to ignore and to not do anything.
No, definitely the course of action is not to ignore and do nothing. I gathered the due diligence that we had done. I spoke to La Palma. I made a decision to address the entire nation. I went on W Radio, which is the largest syndicated radio show in the country, has the largest viewer base, and I said, "Look, rather than hide from this, I want to confront this head on." And I said, "I'm going to talk to every single person that there is. I'm going to make this as clear as possible. We're not running from anything."
Earlier, Mr. Seda, you responded that you had your own due diligence in-house, correct?
Yes, that we had performed a preliminary title study ourselves, yes.
Yeah. So in 2014, when an individual approaches you and makes threats and says that he's the rightful owner of a property that you're building, that you have not started to build yet, but you're preparing to build, if you are a good faith, without fault buyer, wouldn't the normal course of action be to check, perhaps with a renewed due diligence? You could have asked your lawyers or outside lawyers, who's this person? Can you do a check on him? Did you do that? Other than the Google search by your in-house lawyer.
So again, what we did is we looked at the title information that we had in the records of the due diligence that we had done. My in-house counsel reported to me that they didn't find Mr. Lopez Venegas on title, that he was not an owner of the asset. We went on national radio. I went personally on national radio, and I addressed the entire nation on the matter, and the due diligence that we had done was already done. I mean, I'm not sure what we were supposed to do. Just simply walk away from the project. We had already invested a considerable amount of money into the project. And this gentleman seemed like a fraudster, and he didn't mention extinction of domain. He mentioned bringing reputational damage to our property, to our project. He said, "I'm going to go to the press. If you don't do this, I'm going to harm your project by going to the press." And I just simply would like to add one additional thing. I'm viewing this from the lens of a developer who's been approached by a long list of people who've tried to extort us. This is all kinds of extortion attempts. None necessarily like this, but they all come in their own different package. And he didn't seem credible. He disappeared for an entire 2 years. After he did what he wanted to do, which is get this thing on the radio. We confronted it. We didn't hide. He went away.
Did you really confront it? The question is, and I will ask it again, the question is, when you have someone claiming to be the rightful owner of a land on which you're preparing to build. You are building in Colombia, in the region of Medellin, in the context, regulatory context of asset forfeiture. You know the law. Your lawyers certainly know the law. And you know that there's always a risk that if there's a title, a claim to the land, that may stop the process. This is the nature of asset forfeiture proceeding. So isn't the normal course of action to do a further due diligence, to look at other than Google, to ask your lawyers, to ask another law firm maybe to do a Google search, or a title study search to make sure that he is indeed who he says he is, which is a prior owner or current owner? Wasn't that the normal course of action, rather than just ignoring things?
So I did check with counsel. I did check with in-house counsel and out-house counsel. And I asked, what should we do? And they advised us, they said, this guy's a fraudster. You guys did everything within your capacity here. Your diligence goes far beyond what's necessary. You guys are good faith buyers. This guy's talking about a kidnapping attempt, or excuse me, not attempt. He's talking about that while he was wrongfully extradited and in jail, his son was kidnapped, and some issue that had happened more than 10 years before the moment we're talking about. And our view was, and as I said on national radio, we are qualified good faith buyers. We've done everything that we could have possibly done on this title. I believe his issue is with whoever the perpetrators are, if this is even true, who did the crime against him, as he's supposedly saying. I said on national radio, he should go to the authorities. We said that.
The documents that you showed to the buyers, right, you give them comfort, right? You go on national TV, like presidents, you address the nation. So you're saying, I'm a good faith buyer, and you have two pieces of document that you show to the buyers, the Otero study, right, which we saw was 10 years. It actually doesn't look beyond, when we know that asset forfeiture is not subject to statute of limitation. Your lawyer should have told you that, correct? You can go beyond 10 years. Did you ask your lawyers about it at the time?
I asked my lawyers.
Mr. President, if I just may, we don't want to look defensive in any way, but there are a lot of questions about what did you ask your lawyers, what did your lawyers say? I just want to note that we're getting awfully close to trespassing on privilege.
I'm very sorry, this is not about these lawyers in this room regarding arbitration. I'm talking about the facts of the case at the time and how Mr. Seda reacted to what he says to be extremely serious threats. And I'm not asking about the substance of the advice.
So far, it's still permissible,
Thank you, Mr.
but we will continue to observe the further conduct.
Again, I believed he was a fraudster. I wanted to check with counsel. I did. They made an assessment. They looked and said, listen, we did this due diligence. We believe we did it honestly. We did it in good faith. This gentleman doesn't have any true claim to this title. I did all the things that I told you. Going on the radio, I talked to Corfi Colombiana. I mean, we didn't simply. I didn't simply go on the radio and say, "This guy's a fraudster." That's it. I did a lot of work.
Sorry for the interruption, but the transcript, the English transcript, seems to be off. It's working now? Okay, sorry.
Because there may be some delay or drop in the internet connection, and may kind of pull words back until it reconnects and then dumps it. So nothing's lost, luckily.
Thank you. I will wait a little bit longer before I interrupt next time. Sorry.
And then to add one final thing, we didn't receive this information in mid-2014, and then we ran out and started constructing on the project. We continue with the normal course of business. We continued to sell units. Those funds continued to be deposited in a very safe manner in the fiduciary trust, not used by us. We continued to use our own capital to further the project along. And years went by before anything transpired. 2 years.
So you just continued with the normal course of business. You reassured the buyers, you continued to sell, you continued to prepare the construction, right? That's what you're saying.
I continued to move along with the project after doing careful analysis. I continued to sell with the caveat that any of the units sold, any of the monies that were being given to us by unibuyers were given directly to the fiduciary. They were safeguarded by the fiduciary. We didn't start construction for at least a year, more or less a year after this issue transpired.
You did not deem necessary, given the situation and that you have a claim by someone who says, I'm the rightful owner, to restart maybe a due diligence, a serious one, not a Google one. To have an attorney maybe look at the chain of title, to go as far as possible, far back in time. You did not do that, right?
We did not redo diligence. Again, no.
Okay.
We stood by the diligence that we had done.
Okay. And what you did not do either is to actually go and see the authorities and go see the Attorney General's office, right? You didn't do that either.
Colombian authorities scare me profusely.
Do they?
They do.
You say that with a straight face when you invest in Colombia and you've been there for 15 years?
I'm saying that with the face of today, 2022, understanding everything that's transpired in this situation.
For which you have no evidence, do you? Do you, Mr. Seda?
I think we have a difference of opinion.
Well, I'm looking at the facts and the evidence on the record.
I have my testimony. I have the testimony of Felipe Lopez. I'm not sure what other
So what you're
evidence you
saying
want.
is that you simply will not raise the matter with the Attorney General's office, who is competent to determine, when you have somebody who says they're the rightful owner, to determine if that is indeed a claim that's valid. You didn't deem it necessary as a legal matter.
Number one, La Palma Argentina advised me, the land seller, that they approached the Attorney General's office. Number two, Ivan Lopez Venegas wrote a tutela, which I don't know how to say tutela in English, lengthy, large, and we responded, our counsel responded in a fulsome manner to that tutela. I went on national radio and told the entire world what was going on, that this gentleman was extorting us. He was trying to extort. I don't know what else I could have done beyond that to alert the whole nation of Colombia about this.
Can you look at your paragraph 125 in the first statement? Now, I'm jumping a couple of years. We're in December 2016, still talking about Mr. Lopez Vanega. And at the end of the paragraph, 125, you say, I quote, on 19 December 2016, I filed a formal complaint with the Fiscalia reporting Lopez Vanegas' extortion attempts and his claims of influence over persons in the Fiscalia. That is C-181 that you refer to, your complaint of 19 December 2016. So, in fact, you do go to the authorities, right? And you know how to file a complaint, right?
Yes, with context.
2014 is not context?
Is this not 2016?
Yes, but 2014 is also the first time you hear from Mr. Lopez Vanegas.
Definitely not context with regards to this situation.
But my question is, you know how to make a complaint and you know how to go to the Colombian authorities when you feel that you need to hear about extortion attempts, right? You know how to do that.
In actuality, the Colombian authorities had come to me in this specific scenario.
And you file a formal complaint to the same authorities that you do not trust, is that what you're saying?
Again, I believe this singular sentence requires context for the tribunal to understand exactly what happened.
Let's look at paragraph 77 of your first statement. So this is context, Mr. Seda, for you. I quote, although I knew that Lopez Vanegas' claim were false, now is 2016. And I believed Mosquera was part of Lopez Vanegas' scheme to extort us. I felt I had a duty to inquire into the proof of evidence Mosquera claimed to have in order to protect the other investors, the unit buyers, the project, and myself. Accordingly, on 3 May 2016, I told Mosquera that I was available for a meeting. So, after some back and forth, you decide, and that here you refer to Exhibit C157, right? And which I don't know if I have, but anyway, let me see if I have it for you. Yes, tab 40. 40. Mr. Seda? Tab
Sorry?
40.
Yep.
So the same shady person you decide to meet, right? And here you have this exchange of email with Mr. Mosquera, his lawyer. And you say in your testimony that you said that you were available for a meeting. He responded abruptly a few hours later, stating that Lopez Vanegas was no longer interested in pursuing discussions with me, and that instead he would proceed with his defense, right? This is the context we're talking about, right?
To clarify your statement, I didn't meet with Ivan Lopez, nor did I
Precisely.
suggest to.
That would be my next question. Did you meet with Mr. Lopez Vanegas? You did not.
No, did not.
Following this email. So this email is 3 May 2016, right? May 2016, Mr. Seda, is about a month after the Fiscalia launched investigations against the assets held by Mr. Lopez Vanegas. Are you aware of that?
I'm sorry, what are you reading from?
I'm asking you a question.
Oh, I thought you were reading from. Sorry. What's the question?
6 May 2016 is about a month after the Fiscalia launched investigations against assets held by Mr. Lopez Vanegas.
6th of May?
2016.
3 May, you know.
I'm sorry, 3 May. Thank you, Mr. President.
Is about a month after, and I'm sorry, I apparently got
After
confused.
the launch of the investigations by the Attorney General's office. Let's look at it. Maybe that will help you. That is C153 in tab 41. 44, I'm told. I'm sorry. Are you with me?
Yes.
So this is a resolution number 125 dated 8 May 2016. And you see in the English version, second paragraph. What did I say? April, I'm sorry, it's April 2016. So looking at the paragraph in the middle, in English, in a report dated April 8, 2016, the Criminal Investigation Division of the Superintendents of Notaries and Recordation, Land, asked this office, this national office, to assign a filing number for an investigation into the assets held by Ivan Lopez Vanegas, a member of the Envigado cartel. In view of the above and taking into account meeting minutes number 35 dated 6 April, which corroborate the pertinent presentation of the case by the Criminal Investigation Division to the Internal Working Group on Information Analysis, Prioritization and Statistics, led by the Director of the Specialized Attorney General's Office for Asset Forfeiture, at which meeting the determination was made to assign a filing number and priority to this investigation, given that it involves a criminal organization.
I'm sorry. This is the Spanish court reporter. Can you read a little bit slowly, please? So
I'm sorry, yes. At which meeting the determination was made to assign a filing number and priority to this investigation, given that it involves a criminal organization related to the Envigado cartel. Accordingly, the assigned prosecutor may attend to the needs of the present investigation, given that it falls within the central subject matter of emerging criminal organizations, and may therefore carry out the pertinent actions related to the specific case, and may also report for this assignment in the month of April. That's signed by Ms. Ardila, and this is the Ms. Malagon. It's filed by Ms. Ardila, I'm sorry, and signed by Ms. Malagon. So this is the launch of the investigation against Mr. Ivan Lopez Vanegas, right? His assets, right?
I don't know if this is the launch or the reassignment. I'm not sure. I don't know.
Okay, so I represent to you, it's the launch of the investigation, okay, from a legal standpoint. So this is 1 month before your email exchange with Mr. Mosquero to meet with Mr. Vanegas, right?
Before Mr. Mosquera contacted us via email, correct?
And you referred to the tutela filed by Mr. Lopez Vanega. I would like to look at it now. That's tab 41, but I would need to complete it because the version that I have in the binder is not the complete Spanish version. So you will have, and for the record, Mr. President, and you will be given also the full document. So there's 037 bis full
Okay.
document in Spanish, which will be given to you now.
Amazing. Let's just drop it in the binder.
41.
How do you want to do this?
And then,
Okay.
Mr.
Sure. That works as well.
Yes, I don't think it's the complete version that you have. So now it will be given to you, the complete version in Spanish. I will wait for it to be given. Thank you. So there's what you're receiving is one complete Spanish version and two translations into English, one by the claimants, the other by the respondents. They correspond to different sections, to different parts. So the one that is provided by the claimants is the one that starts with SP001 and continues with 0017. And the one by the respondent is SP001, and then the next page is 49. So the tutela is essentially a measure of protection, right? As you understand it. Or if you don't want to, if it's legal, you're not comfortable, I'm more than happy to
I think it's like something to, and I'm giving a very general understanding how I understand, like to protect constitutional rights, like that are, again, I'm not an attorney, I don't know. More or less, like to protect like some right that may be taken from you very quickly or that needs to be remedied quickly.
You raised the tutela, so are you familiar with it, with the tutela of Mr. Lopez Vanegas?
I reviewed it. I mean, it was a big document, but in general, my attorneys handled it for the most part.
You reviewed it at the time, or did you review it in the context of the arbitration?
No, more so after the fact. It was a huge document. I think the response time was something like just a few days.
So, the date is 6th of May, 2016, right? So the exchange you have with Mr. Mosquera is 3 May, correct? We just saw it.
I mean, I'm trying to remember if we're talking about literally a difference of a day or two. If you could bring the email up again.
The email is C157, which is tab 40.
Sorry.
You can look at the tab, yes.
This is the date that Victor Mosquera emailed us.
Yes.
Okay.
And in your testimony at paragraph 77, that's where you explain probably why did you not meet him. You say that Lopez Vanegas was no longer interested in pursuing discussions, and instead, on Lopez Vanegas' instruction, Mosquera would proceed with his defense. So presumably, this is the tutela we're talking about, because this is 3 days later, 6 May, right? Presumably.
Are you saying 6th of May was the date of the tutela? Or
Is
the
the date it's submitted, right? It's filed.
I don't know. My recollection is I did not respond to Victor Mosquera's email until after the tutela. That's my recollection. I don't know the exact date, but I'm happy to review.
Okay. The dates are in the document, so it's easy.
Yeah.
It's not a big issue anyway. So I'm just trying to establish the chronology. So if you look at the Spanish version, it's probably the best because you read Spanish and it's the most complete version. So if you look at, and since you've seen it before, page 18, SP 18 in the Spanish version.
I'm sorry, where are we? What are we looking at?
SP 18 of the Spanish version of the tutela, which is just handed to you.
This document.
I don't know where if you put it in the binder,
I didn't.
I can't
I didn't
see.
put it in the binder. Apologies. This is it. Okay. SP 0018.
8, yeah, 18 says 1-8. So you see that here he starts discussing the actual case, right? Describes himself. You see on the next page at paragraph 67, he refers to 1995, the year 1995, and he describes what happened then. If you go to the next page, paragraph 68, that's where he discusses the consolidation of the parcels. We discussed that yesterday. Moving to the next page, paragraph 73, we discussed that earlier. That's the renaming of Sierra Alta Lopez Compañía to Inversiones Nueva, right? He discusses that. And then if we go a bit further, page SP 0036, that's where he discusses the system of financing of the Envigado, right? Crimen organizado. Here he discusses the facts. If you go to page SP 0039, you see that here there's a recording of a conversation with Mr. Arboleda. This is the mango seller, the front man for the property. That's obtained by Mr. Lopez Vanegas through a private investigator. Last page, SP 0057. These are the annexes and exhibits, and you see that there's a number of deeds he provides, escritura, etc., etc. So exhibit 7, 8, 9, 10, etc. Is submitted to the Attorney General's office, right? And this is 6 May. You've read this document before, right? So you're familiar with it.
I've reviewed this document in general. I'm not sure what you're asking me to take at fact. The testimony of a, as you've proclaimed it, a known drug trafficker who says that he's never drug trafficked before, that he's a simple businessman and a abiding citizen who's been wrongly prosecuted and has never done drug trafficking before. You're asking me to take his written statement and take it as fact? I don't know
No,
what you're
I'm not
asking.
asking you to testify to his facts at all. I'm asking you, first of all, if you're aware of this. And what you see is that when he files with the courts his tutela, he's describing very specific facts about the chain of property in relation to what is now the meritage. Right? That's what you see in the document.
He's describing, first off, to be clear, I don't know this document in depth. Okay, there have been so many documents in this case, it's insane. With regards to what he's describing a narrated story of individuals who are not on time.
Well, if you
so I'm
look-
not sure what you want me to get out of this document.
I'm trying to establish facts, Mr. Seda.
You're just trying to establish what?
Facts. So if we look at,
I don't take these as facts. That's for sure.
well, it's a fact that the tutela was filed with the courts in May 2016, right? That's a fact.
That is a fact.
This document is a fact.
It exists. That's correct.
Right. And that the courts were then seized of this matter, and that the Attorney General would become aware of the substance in this tutela, that's also a fact, right? As of then, it's all out.
Yes, I believe this tutela, after the fact, the judge made the determination that he was not going to stop construction, was not going to revoke our construction license, was not going to take the property from us. And I believe, I don't want to mischaracterize this, he said, Fiscalia, I turn this over to you and do what you guys are going to do with it. But do something quickly.
Who? Mr. Lopez Vanegas?
The judge.
The judge turns over what? To whom?
I believe his determination at the end of this was, I'm not, with regards to the request of the tutela of Victor Mosquera, the attorney acting on behalf of Ivan Lopez, the requests were to cease construction, revoke the construction license, and take the property from the existing title holders or property holders and give it back to Mr. Lopez. He denied number 1, number 2, and number 3. And he took, from my recollection of this, my very, let's say, high-level recollection of this, and he referred it to the Fiscalia and said, here, look at this.
And as we saw, the investigation had been launched a month before. Right?
I can't confirm if it's been, I don't know that level of detail into the investigations and when exactly, and I mean, I don't know. What is their point or question? I don't understand.
That's my question. It would not have started if they were so friendly to Mr. Lopez Vanegas. If they wanted to help Mr. Lopez Vanegas, no investigation into his assets would ever have started. Isn't that correct, Mr. Seda?
I think we have a difference of opinion on how the Fiscalia works.
That's a fact, Mr. Seda. Investigations were started against the assets of Mr. Lopez Vanegas. Yes or no? You saw the document.
I think that what we discussed is they were looking into this particular asset based on the fact of a trumped up kidnapping story. Not because he was this drug trafficker. I mean, I think we read the determination of the claim yesterday, and it said very clearly they started this investigation because of a kidnapping that the Fiscalia, the U.S. government, and many individuals have all said is simply false.
And because Mr. Lopez Vanegas made a lot of noise about this property being his right? So when prosecutors are confronted with claims, they're duty bound to look at those claims, especially if those claims come from somebody who's associated with a cartel, correct?
I don't know exactly how the Fiscalia works.
So you don't know. You cannot assume you don't know. You can say you don't know.
Again, I think that we have a difference of opinion on why this investigation was started, on what the purpose of starting the investigation was, and what the outcome that the individuals that were involved in this, including individuals from the Fiscalia, what they expected.
And again, the chronology is not in your favor, is it? Mr. Lopez Vanegas makes a lot of noise from February, and that's in his tutela, from February to April. He brings up new facts, new elements with deeds that he apparently can find. If your lawyers cannot find, he can find them. He brings that to the courts, he brings that to the Fiscalia, and on that basis, the prosecutors are duty-bound to have a look. And they do that exactly on 8 April, they start investigations into the assets of Mr. Lopez Vanega. That has nothing to do with cahoots, because then, that is not even before he has filed his tutela. So they start, if they were so friendly to Mr. Lopez Vanega, they would never have started investigations. Correct?
I think the chronological order or the timing of things speaks for itself very clearly, very clearly. And why they would start this is because this would be a tremendous lever of pressure against a developer like me.
And what is exactly the interest of the Fiscalia in doing that? They're investigating the cartel. They're duty-bound when somebody says that this is a chain of property belonging from A to Z to cartel people. They're duty-bound to investigate that. That's exactly what they do. What does that have to do with you? If you find yourself in that context because you have bought that piece, then the natural thing would precisely to go to the Fiscalia and say, I'm a without fault buyer. You didn't do that, did you?
I think you have to understand the context in which the Fiscalia has been an organization which has been riddled with corruption. And I don't want to misspeak. I think we have an article on record where the Attorney General himself says, above drug trafficking, the number one issue that we have in Colombia, and this is said by two Attorney Generals, both Néstor Humberto Martinez, who was the acting Attorney General at the time that this all happened, and Barbosa, who was the next Attorney General. He says, and above drug trafficking, the number one issue that we have in Colombia is corruption, particularly in our public institutions. So, I mean, he started a special task force just to combat corruption within the Fiscalia. To pretend that fiscales are not doing these things is, I mean, do you know what the DNE is? Departamento Nacional de Supervivencias?
If the Fiscalia is looking into any wrongdoing or allegations of wrongdoing, they're doing their job, aren't they?
If they're looking, I'm sorry, I'm just going to repeat this, but if they're looking into allegations of wrongdoing, then they are doing their job. With a lens that they're not acting in an improper manner, then yes, I would agree with you.
So you cannot say the entirety, the universe of the Fiscalia in entire Colombia, these are corrupt people. And therefore, that entitles you to not do anything, to not preserve your rights, and to not abide by the law, which is that if you want to establish that you're a good faith buyer, you have to play by the rules and you have to go to the Fiscalia and raise the matter with them. Otherwise, you run the risk that there will be an investigation into the chain of property by the cartel, and that concerns your property.
I definitely don't think that everyone in the Fiscalia are corrupt. God, I hope not. I hope not. For the country's sake. Again, as I've stated many times, I felt that we made everyone who we could make aware of the situation. We responded to legal claims against us. We went on national radio. We talked to the fiduciary. I mean, I honestly don't know what else we could have done.
Isn't it what you did, Mr. Seda, that you actually rushed into making sure that the buyers are comforted, and you start the construction in 2015 because you just wanted to start construction?
You
And
think-
that was your risk, starting construction rather than making sure that you actually look into this with the Fiscalia and make sure that what you say is your property is taintless and cannot be taken away because it is a chain of property by the cartel.
If you characterize going on national radio and then waiting a year to start construction as rushing into things, well, I think we have a difference of opinion on that as well.
Well, you did say earlier that you rushed into continuing to sell and to prepare for the construction. So you didn't stop your business, you just continued as normal.
I never said the word rushed into. I
But
promise
you
you
said,
that.
yes, you said not rushed, but you said I continued business as normal. Is that normal? Lopez Vanegas coming to and extorting you, is that normal?
Well, to clarify, what I said to you was we did an analysis. We talked to the fiduciary. We looked at the world of information that we had, went on national radio, and then, and only after then, after we made clear and transparent to everyone that there was, we opened our doors, we received emails, we sent out emails. I believe we sent out, and I hope I'm not misspeaking here, I believe we sent out, or one of our staff sent out a blanket email to all the unit buyers with a copy of the title search and a copy of the Fiscalia's report. Then after that, I sat down, I want to say with, at least at a minimum, 85 to 90% of all the unit buyers. Now, we had hundreds of unit buyers. It was an undertaking that I've never done on any project before. I sat down with every single person and I went through all the documents with them and I gave them copies of the documents. I don't know what else we could have done.
You gave them copies of a study, title study that was incomplete, and of a response to a limited query, which was also incomplete. Right? And then at the very latest, with the tutela, it's public, so you should know, it's Mr. Lopez Vanegas bringing up a number of facts and circumstances with evidence, and he actually refers to deed 1554. That's at page SP 0019 of the Spanish version. And that is the one that was picked up by Coffee Colombiana's lawyers. So if you had someone to look into that again, you would see that there's a problem at the very least. Correct?
Are you stipulating that if we had found that one individual thing and run Mr. Ivan Lopez's name through OFAC and the UN sanctions list and Interpol lists and every other list that there is, that we would have found something? I don't agree. I believe a world of people have done this analysis that you're talking about, and not a single one, please let me finish, not a single one has ever found, including a myriad of financial institutions, fiduciaries, government agencies, no one has ever found an issue with Mr. Lopez. This is my personal opinion. I'm not a professional, a title search professional, but I think you're mischaracterizing.
Mr. Lopez Vanegas has found them, right? On the last page, you have the exhibits. Mr. Lopera. Mr. Lopera, who you referred to in your statement, the lawyer for Mr. Lopez Vanegas. I'm sorry. Oh, I'm sorry. Yes. Okay. Sorry for that. I was not finding the reference. So this is paragraph 7, which we saw earlier. So when you ask your lawyer, Mr. Lopera, to conduct an internal search, which is when it showed up that he's a drug trafficker. So the very basic Google search shows who he is, right?
I'm not sure exactly what Mr. Lopera did to find. I don't know how much time he spent. I don't know if he spent an hour, 2 hours, 10 hours, taking the information given to find this individual. I don't know. I don't know. That.
There are closure orders, Mrs. Seda, that your lawyers refuse to have on record. Okay? So, now, if we can go back to this document.
Mr. President, with respect to that, we hadn't reviewed the 2,000 pages from last week, so it's not that we've refused a specific document. I just want to be clear about that.
Let's proceed.
Now, I would like to go back to, actually, no, it's a new document. That is Exhibit C33 bis. This is on tab 18.
I'm sorry, tab 18?
18, yes,
Okay.
1-8.
Of course.
You have it?
I do, thank you.
So this is a petition response from Corfi Colombiana to Newport, dated 26 July 2017. Are you familiar with this document? As I said, it's addressed to you. The answer is yes, Mr. Seda?
I just need a little time.
It's addressed to you. Are you familiar with it or are you not?
I don't remember every single document ever sent to me. No.
This is an important one.
My
So, for the
memory's limited.
record-
Would you like me to read it?
For the record, I will say what this is. So this is Corfi Colombiana responding to a request for information. And I'm interested in the English version, SP 0004. So reading for the record. In the particular case of establishing trusts related to the Meritage project, it is important to note that it was not fiduciaria, but the trustor Newport, which directly negotiated the acquisition of the project's plots with the company La Palma Argentina, without intervention by fiduciaria in said pre-contractual stage. Nor must we lose sight that according to Decree 1023 of 2012, and external circular letter of February 19, 2014 of the Superintendents of Companies, non-financial companies operating in Colombia are required to design and implement an adequate internal system of self-control and risk management, LAFT, which includes but is not limited to due diligence in the knowledge of customers or counterparts. In this regard, for establishing trusts related to the Meritage project, the applicable financial legislation does not contemplate the obligation for the trustee fiduciaria to have any type of approval issued by the compliance officer of the entity, but rather to comply with each of the aforementioned obligations set forth in Part 1, Title 4, Chapter 4, etc. of the basic legal circular letter of the Financial Superintendents of Colombia obligations that were fulfilled by the trustee. For the reasons stated, the approval that you request to receive at this point does not exist. Right, so that's two important points. The first is that they refer to the negotiation for the acquisition of the property with La Palma having been done without their intervention. And they say that Newport has to comply with, you see in the first paragraph, design and implement an adequate internal system of self-control and risk management, right?
I see the paragraph, yes.
Do you remember reading this at the time?
To be honest with you, completely, no. But I understand what it says.
So what it says is that they will not approve, and that the responsible party for checking the identity of the contractor counterparty is Newport and not Corfi Colombiana. That's what this says, right?
It says a lot of legal terms, to be completely honest with you.
Do you understand?
More or
Required to
less,
design and implement an adequate internal system of self-control and risk management. Do you understand that?
I do understand that. I don't agree with it. I do understand it.
That's what Corfi Colombiana, your fiduciary, tells you. You like to rely on them, so here this is what they say to you. It's not my responsibility, it's yours.
So what is the question?
That's my question. You rely on them the rest of the time, but when they say, it's not my responsibility, it's yours, you choose to just ignore it.
I'm not ignoring that. I would be taking advice of counsel in the sense that what one has to do for regulated and non-regulated entities, and then if you are, I think it's, supervised or not supervised, and if you become regulated, it's you have more than 160,000 minimal salaries, and we looked at this, and our council came to the conclusion that we are not regulated or supervised entities, and we don't have to.
Did you show this to your lawyers when you received this, since you said it's legal?
I give all my documents. What attorneys are we talking about?
Your in-house lawyers, I don't know.
Yeah, I mean, I give all my documents to my attorney. Most of the documents, every document that comes through our office.
So they could read this and understand that it's a legal obligation for Newport to do due diligence and to implement an adequate internal system of self-control and risk management, right?
So we have reviewed this, and the response that came back from council is we do not, at that period of time of 2014 and or 15, I believe, because we didn't meet the thresholds. So Newport was not managing more than 160,000 minimum monthly salaries per month, and so we didn't meet it. That was the advice of council. You do not have to. It's simply wrong.
So essentially, Corfi Colombiana is telling you, we're not doing this, we're not responsible, it's your responsibility, so they probably know what they're talking about. And this is a legal requirement, and you choose not to do anything, even assuming that under your interpretation you don't have to. Nobody does any diligence then on that basis.
That's not what I'm saying. You're mischaracterizing what I'm saying. What I'm telling you is, you're asking, do you have to do this? Do you have to implement this? Is that what you're asking? Maybe I'm answering a question I don't even have to answer.
No, I'm not asking you, I'm
Okay.
telling you, Corfi Colombiana tells you it's not their obligation, so they will not have an approval, because they don't have an obligation. It's your obligation by law.
Well, let me finish reading the paragraphs, the previous paragraph and the paragraph thereafter, and then maybe it'll help me get context and understand exactly what they're saying. I don't view it the way you're viewing it. If you want me to read it, I can read it and tell you what my opinion is on it.
I read what Corfi Colombiana told you, that's all. And I'm asking you, did you actually do something about it?
Did I do something about what?
What they tell you about your obligation, Newport's obligation.
Yes.
But you said that
Yes,
it was not.
we
it
talked
was-
to council, but hold on. You're asking me to answer a question. You're asking me if I did something with regards to this, and I'm trying to answer that. So what I'm answering to you is, we conferred with council, and council said, this doesn't apply to you. You do not meet the minimum threshold. You didn't have to do it. It's not the situation.
So what do you do then? Do you go to Corfi Colombiana and say, I don't agree?
Are you ready to discuss council conversations?
No, I'm asking what you said Newport says to Corfi Colombiana. As a result, if you don't agree with the interpretation, what do? You just leave it there? Corfi Colombiana is telling you it's not my responsibility, it's yours, by law. You determine it's not your responsibility. On that basis, do you go back to Corfi Colombiana and say, I don't agree with your interpretation?
What we were doing was simply having Corfi Colombiana asking them, I believe, hold on. In order to even tell you, I need to read the letter and understand.
I'm sorry?
In order to tell you what we were trying to do, because I'm
Go
reading a
ahead.
response to. Do
Go
you have
ahead. I
our
told
original
you,
letter?
You always should take the time to read if you need to read. Go ahead.
Okay. Can you give us our original letter to this? Do you have it?
It must be there. As usual, after the color paper.
I don't. Let's see. I don't see it. Can you refer me to where it is?
We're checking if there's a Spanish. You don't have anything in the binder?
I mean, I know there's a lot of documents here. I just like faster
It
for
should be
you,
in the
faster
same
for
tab.
me. Yeah.
You just need to turn the page, Mrs. Seda.
Thanks. Again, this is a response. I would like the communication that we are asking. You said we wrote to Corfe Colombiana and this is their response, right?
Yes.
This is also from Corfe Colombiana to us, so that wouldn't be the letter.
This is Kofi Colamina's response to you, yes.
Sorry.
This is what we've been talking since 5 minutes
What
ago.
I'm asking
Mr.
about.
Mr. Seda wanted to see the letter to which this letter replies.
Your petition of 4 July.
I would like to have context and understand what we were asking for and what they're replying to. It's hard for me to respond if I don't have that context.
We're looking if it's on the record. So apparently it was not filed by your lawyers, so we don't have it on the record.
And then taking that in consideration, I apologize, but I just would like to read the entire letter to understand it. Is that okay?
Yeah?
Thank you. And this helps considerably. One more second. Okay? Would you like me to answer? Okay, so what I understand from this letter is, without seeing the letter that we sent them, it seems like we were asking for some sort of concept or opinion. And for my reading of this letter, what it says is, we'll tell you with regards to these transactions, we did all of these studies, we did all of these things, we followed our internal SARLAF system, we estudios de títulos, sorry. I'm going to try, if you could put the English version back up, please. And go to SP-0002. If you could go a little further down the page. And so it's saying compliance, and they've done all of these things, and they've gotten all these studies, and they're basically saying that these are all the things that made us comfortable with the deal. But then it seems like they're getting very, very narrow, and they're basically saying, you know, so it says they're not issuing a concept. It doesn't say they didn't do the due diligence or didn't study. I don't see where it says they didn't study the counterparty.
If you look at the passage that I read, which is page 4,
Yeah.
they're simply saying that it is for Newport, who is the direct negotiator with La Palma, without intervention by Coffee Colombiana.
Yeah, you're mischaracterized. I'm sorry.
I'm not mischaracterizing anything, Mr. Seda. This says that Newport has an obligation by law, right?
It's saying we didn't do the deal with La Palma. You did. However, nor must we lose sight that according to Decree 1023 of 2012, an external circular, Superintendencia, non-financial companies, so that one's not contingent on the other. I'm not going to try to be an attorney here and say exactly what this
Right.
means, but the way I understand it, you're asking my opinion, and my opinion is it simply saying, A, we didn't do the deal with La Palma, you negotiated it, let's be clear there, and second, corporations of this who are regulated by this must have a SARLAF system. I mean, those are, one doesn't require the other.
What it says is that they will not give you any type of approval issued by the compliance officer of the entity, and they conclude that the approval that you request does not exist. And they say that the requirement is a requirement on the company itself, is Newport.
Where exactly are you reading from?
The 2 paragraphs that you have
Okay. When you say it doesn't exist,
at the end, the last
of the
sentence.
of the last paragraph? Okay. Yeah, they're saying the concept. They're saying you're asking for a legal opinion, a concept, and they're basically saying we're not going to give you a legal opinion, a concept.
Why do you say
it's too-
concept? It said the approval that you request to receive does not exist.
It's difficult to further go on with this because we do not have the letter of the 4th of July. So I think if we had the letter, the answer would be clearer.
Which I do not have because it's not on the record.
Yes,
unless I'm
but
mistaken.
so it is not so helpful to go on with this.
I'm happy to move on, Mr. President.
Yes, please. But let's have the afternoon break then, rather, and resume at 3:48, please.
Yeah, it depends on the, the speed of the change.
Yeah.
Some, it'll eventually catch up, but not at the right moment.
I'll be very patient next time.
Well, that's why I like wider system.
Yeah.
That doesn't happen.
Yeah.
So we are ready to resume.
Thank you, Mr. President. Can you look now at your second statement, paragraph 27? Ms. Noguera, you refer a lot to Ms. Noguera, so that's in paragraph 28. And that at paragraph 28, that I understand is the first meeting with Ms. Noguera, right, in December 2019?
That is correct. That is correct.
So let's look at your second statement now at paragraph 30. I'm sorry, we're there. So this is the meeting we're talking about. I'm sorry. Now, if we can look at exhibit C24, that's tab 28. Bis, yes. Thank you. Tab 28, Mr. President. That's from the Attorney General's Office, Asset Forfeiture Unit. It's a petition to Asset Forfeiture Court dated 5 April 2017. And you see here on the bottom of the first page, requerimento, and then you see on the second page, identification on top, identification and place for notifying the impacted parties and intervening persons. And one, there's a reference to Ms. Gladys Lucia Sanchez Barreto, legal representative of Sociedad Newport. I'm sorry, that's page 151 of the document of C24 bis, which you see on screen. So you see that in 2017, on 5 April, the Fiscalia actually recommends that Newport be admitted as an affected party, right?
Yeah, I don't know how to translate this in legal terms. I don't know if this means that they're recommending that these people are to be third parties. I don't know if it's saying these are individuals who are trying to become third parties. I couldn't give you a perspective on this. I'm not well versed enough.
It says, can we look at the Spanish version? And you have it in the binder?
Oh.
As usual. Identificación y lugar,
Where would it be located? I don't.
as every time after the pink page.
Thank you.
Identificación y lugar de notificación de los afectados. You see that? So it's a list with Newport on top, identified by the Fiscalia as
Just give me
afectado.
1 minute to read it. Apologies.
Yes, I'm just setting out the stage and then you can read.
Mr. President, I think the last word is important. I don't speak Spanish, but it's not just affected parties. It's and interveners.
So with regards to this reading now the Spanish version, switching to Spanish now. Identificación y lugar de notificación de los afectados e intervenientes. I'm not an attorney, an EDD attorney. I don't know exactly what this means, but my interpretation would be people who they think are affected parties and people and or people that want to be recognized, not necessarily that they're saying that they are recognized as afectados.
I'm trying, since I didn't hear, I'm looking at the transcript to see what you said. It's a recommendation, is it? It's a recommendation to the court, right?
I can't, again, you're asking me legal advice. I can't
Well-
tell you what the what would you call it? The interpretation of this from a legal
No, I'm
perspective.
asking you the very simple question, and the rest can be done by your attorneys as legal matter, and so can we. And what I can just say for the tribunal's clarification, intervening persons as per the law, as for the asset forfeiture law, concerns what you have in 3 and 4, the Attorney General's office and the Minister of Justice. So these are the intervening parties, and then the actual afectados would be here Newport and Corte Colombiana. This
Would
is
make
the
sense, yes,
recommendation
but
of the prosecutor. So my question is very simple, not getting into legalese. Are you aware that in April 2017, the prosecutor recommended that Newport be admitted as an affected party? Yes or no?
Again, I'm looking at, I understand the document in
Were
the
you
sense of,
aware at the time, Mr. Seda?
was I aware of this document?
Were you aware at the time, somebody told you, yes or no, that
No
there was a
one-
recommendation that you be admitted as an affected party?
No, no one has ever told me that the Fiscalia recommended us to be an affected party. Never.
And Mr. President, just a point of reference is Article 31 of the law on asset forfeiture procedure, on intervening parties. Then if we can look at Exhibit C 436. You're familiar with this, of course, your lawyers, tab 29, your lawyers extensively argued this document yesterday. This is the decision of 22 April 2022 by the Superior Court of Judicial District of Bogota, admitting Newport as an affected party. That you're familiar with, right?
I'm familiar with the generality of this document. I've read it. Yeah.
And when you say in your first statement, paragraph 82, in a different context, admittedly, this is in the context of Mr. Lopez Vanegas, I would never pay a bribe. I was confident that the Colombian judicial system and authorities would reach the right conclusion. So you were right being confident, right? Because the Bogota court has admitted you as an affected party now.
I'm saying that in the context. Let's say 1 second.
I did say it in a different context. I'm just taking your statement that you're confident in the Colombian courts.
You haven't let me finish. I'm saying that in the context, and we had controls of legality out there. I'm saying this is in the judicial system, not the court system, that the Colombian judicial system, and it's also referring to this principally referring to the Fiscalia. I felt that the judicial system, and speaking about the Fiscalia, was not gonna, was not gonna come against us.
The judicial system includes the Fiscalia, right?
It does.
Yeah.
I'm sorry. I can't attest that this document is them saying, the Fiscalia saying, or the prosecutor saying that we should be affected parties. I mean, you're asking me to come to a legal conclusion. I just,
Let's take
I
it
don't know.
differently. I represent to you that this is a document where the prosecutor recommends that Newport be admitted as an affected party. That's what this means, isn't it?
I don't know.
So now let's look at your third statement, paragraph 2. You referred to this. This is an important paragraph. I want to spend some time on it.
Okay.
would like now to go to your first statement, Mr. Seda, at paragraph 104.
Paragraph 104?
Yes. This concerns your different approaches and discussions with the U.S. authorities. So here you say it's in relation to still Mr. Lopez Vanegas, and you say, I quote, I was particularly concerned at the apparent fact that corrupt actors in the Fiscalia were complicit in Lopez Vanegas' extortion and were in fact extorting me themselves. Not knowing whom to trust, I sent a desperate plea for help to the U.S. Embassy and traveled to Bogota to meet with an embassy official on 6 September 2016. And here you refer to two pieces of evidence, C-171 and 172. These are essentially, we can have a look at them. These are, I don't have any particular question, I just want to, if you want to see them, you can see them. C-171, that's tab 31. If you look at tab 31, you see that there's an email from you to the U.S. Embassy, and then on top, starting with the page 1, they tell you the American Citizen Services Unit at U.S. Embassy Bogota is available to meet with you on Tuesday morning, September 6th. So this is the meeting that you discuss at paragraph 104, right? Yes, Mr. Seda?
Correct.
Yeah. And you did meet with someone at the embassy, right?
Yes.
Then if we go a bit further down, I'm looking at it chronologically. So still statement 1, paragraph 116. Now we're in October 2016. Here you say that on that date, Mr. Michael Burdick, the Federal Bureau of Investigation legal attaché at the U.S. Embassy, requested that I meet with him. I agreed, and in an effort to gather evidence of the extortion, which I had been subjected to, turn over to him, I contacted Mosquera to arrange for another meeting. And here we can have a look at the document that you reference here, that's C-179. That's 33, tab 33. It's a very brief exchange with Mr. Burdick, where where you say first that you spoke with his colleagues at the embassy concerning the meeting. I'm sorry, he says to you, I spoke with my colleagues at the embassy concerning the meeting you had with them. I would like to meet with you. And then further up, he says, I will be in Medellin on December 13th. Please advise if you have time to meet. I understand that you did not meet Mr. Burdick, right?
No, he didn't follow up for the meeting.
Then, still going ahead in time, on 29 November 2016, that's exhibit C-178, tab 34. That's a letter from Richard Walsh, the General Consul of the U.S. Embassy in Colombia. And essentially, he's picking up on your complaints, and he says that he recognizes that you have met with Miss Elizabeth Gracon, I think. And second paragraph, he says, as you know, the embassy cannot provide, and this is in relation to the physical issues and threats that you had discussed, the embassy cannot provide physical security. I understand that Miss Gracon recommended that you make arrangements for personal protection if you believe that the Colombian authorities cannot adequately protect you. And then last paragraph, regarding your ongoing legal dispute, the U.S. Embassy can only offer limited assistance in resolving your civil legal matters. In cases such as these, the Embassy recommends that you hire an experienced attorney to pursue your case in the local justice system. I understand that you have representation in Colombia and are satisfied with your legal counsel. You have alleged serious corruption in the judicial system, but this too needs to be addressed with Colombian authorities. So that's the U.S. Response to you, right, in relation to those allegations of corruption, right?
That's the letter that was sent by the embassy.
And the final approach, as I understand it, is the December 2016, which I understand to be a meeting with Mr. Neff. So that's your first statement still at paragraph 126. I quote, U.S. authorities also seemed interested in what I knew about Malagon's corruption. On 22 December 2016, I received a WhatsApp message from a person purporting to be a U.S. Drug Enforcement Agency, DEA official named William Neff. And then you go ahead and explain that you were not quite comfortable with that because one of your colleagues had thought recognizing Mr. Neff from the WhatsApp identity, right? And then you say, paragraph 127, I met with Neff at the U.S. Embassy in Bogota on 27 December 2016. Also present were persons from OFAC and the FBI. These officials acknowledged that Lopez Vanegas' kidnapping story was false and the precautionary measures had not been properly imposed on the Meritage. They also extensively questioned me about what I could tell them about Malagon's corruption. So that is the meeting where you were concerned about the identity of Mr. Neff and he met you outside the embassy and took you in, right? That's my understanding of the context.
That's the only meeting that I had with William Neff at the embassy.
Right. And just to be clear, I'm referring to C182 at your tab 35. It's a quite long exchange, so I don't propose to go there, but it's you really being concerned and saying, I don't feel comfortable, I don't know who you are, I need you to clarify your identity, and then at the end it stops at he's at the gate. So that's when you actually met him and went into the embassy, correct?
Yeah, I had serious security concerns. I wanted to make sure that who I was chatting with was actually a DEA agent, was actually from the embassy. I wanted to make sure that I was actually going to meet with some. I didn't want to show up to an ambush, and so that's what concerned me more than anything else.
Right. And then that's the meeting where OFAC and FBI were present, and you discussed what I just mentioned, right? At paragraph 126. I don't know if it's still on screen.
Correct. It's the only meeting I had with William Neff.
Related to the land, which is seized for assets for future proceeding, isn't it?
It appears to be referencing the property, yes.
Yes. Let's look at one last one. This is Exhibit R123. That's tab 38. It's a letter of 26 July 2017. And actually, you have both the Spanish and the English version. I would like to look at both because the English version is, in fact, not a good translation. And again, this time is signed by Mr. Burdick, the same, to the Colombian authorities again. And it refers to, you see the first paragraph, it refers to the United Nations Convention Against the Illicit Traffic in Narcotics, Drugs, and Psychotropic Substances, signed in Vienna and ratified by the US, right? This is the basis for their action. And it says, in the English version, the FBI is investigating a transnational criminal network dedicated to drug trafficking into the US and to favor money. Well, that's where the Spanish should be looked at. It says, the Spanish version says, dedicated to drug trafficking abroad, al exterior, and money laundering, y lavar dinero, right? Right. And
Yeah.
the normal understanding would be that FBI the OFAC and all of the US authorities looking into drug trafficking, DA, that they would actually give this information, and this is internal to the US. What is the purpose of the US feeding back to Colombia information that Colombia is giving to the US? It doesn't make any sense, does it?
I don't know. I can't comment on that. I can tell you that they looked into everything and nothing came out about it.
And you're talking about OFAC.
Well, I'm talking about everything.
You're talking about
The
OFAC.
world of everything.
Well, there was an investigation by OFAC, as you say in your statement, and you said that it ended up with no results, right? That's an
That's
OFAC
correct.
investigation, right?
That's one of, well, I mean, you're referencing this. Well,
Okay, I think
I'm-
we should have now another afternoon break, unless you have an ultimate question
I
on this
have one
action,
ultimate
on this
question, Mr.
letter.
President. Thank you for your
Please
patience.
try to be short, because the court reporters now need a break.
I'm really sorry.
So-
I'm done, Mr. President. Thank you very much for your patience.
Very good. So
And thank
we
you,
will
Mr. Seda.
resume at 5:45, please.
Did that mean you're done your cross-examination, or we need
Yes,
to-
I am.
Okay. So we would still like a break, but I just wanted to make sure that whether I should be preparing some redirect questions during the break. Okay.
Thank you for having asked the question, and 15 minutes, okay?
Thank you.
and just to confirm, that means I'm still, okay. 15 more minutes. All right.
Mr. Seda, you're still under testimony, the same rule applies.
Yes, sir.
Thank you. Well. we then go to redirect, Mr. Molu?
Thank you, Mr. President. Mr. Seda, I just have a few questions for you. Can you see me okay? There's been a lot of innuendo today, so I just want to clear up a few things. Have there ever been any criminal proceedings against you brought in the U.S.?
Never.
What about in Colombia?
Never. Well, no, never.
Have there been some investigations though that you?
So I'm confusing investigations with criminal proceedings.
But have you ever been charged with any crime or anything like that
Never.
in Colombia?
Never. And when I paused, I was referencing a fraud claim with regards to the Meritage thing brought with. Yes.
And have you ever been put on any blacklist that you know of?
Never.
OFAC,
Never.
UN Security Council list,
Never.
Interpol?
No. I've never been arrested. I've never had any issue in Colombia or in the U.S. I've never
Or anywhere else in the world?
anywhere ever.
You know, after all of this, it was suggested that Colombia hasn't kicked you out, you still go to Colombia. Why do you still travel to Colombia? I mean, it was raised yesterday, there was a chart.
Let's proceed, please.
Redirect is supposed to be based on classification, not on generalities.
I'm in the tribunal's hands.
No, proceed, please. Rephrase the question in a manner that is more acceptable.
It's been suggested by the other side that, there are still activities that you're doing in Colombia. There were many things that post-2016 that you were referred to. You still are doing several things in Colombia. A number of them were discussed today, including today. Why?
Because I'm defending my name, and because this is going to follow me no matter where I go, no matter how long it takes, no matter how long I run. This will follow me until I close the chapter in this. So, look, I ran with my children for 2 years, and there was a moment in time where my children said they wanted to go back to Colombia, and I think I came to the realization that I have to put the final nails in this coffin, this issue, and running away is not going to get this solved. And whatever the consequences are, that's what they are. But I want to put an end to this. I do.
I think that's it.
Okay. Yeah, please.
Thank you, Mr. Seda. I want to follow up on an issue that was raised earlier today, this morning, actually. Counsel for the respondent took you to Exhibit C-160. This is the Osorio and Moreno Abogados title study, so a subsequent title study to the Otero Palacio when this was done in 2016. So you recall that exchange that you had with counsel for the respondent, correct? This morning.
I'm sorry, I remember.
Well,
the
you
exchange
recall
I had.
she showed you.
Correct. Yes, of course.
The,
yes.
the document, and I I'm not going to take you to this document, but I will take you, if counsel for the respondent can have, oops, sorry, I just closed it. But the Otero Palacio, I think it's C30, correct? Thank you. So, anyhow, Ms. Benefitemi took you in the Osorio and Moreno title study. To a paragraph that says, and I'll read it in Spanish. De acuerdo con la documentación aportada, el inmueble objeto de estudio se encuentra libre de todo gravamen o limitación de derecho de dominio. Do you recall that?
I do recall that.
What is, in your understanding of a gravamen?
Like,
It was
tax
translated
lien?
by
Sorry.
counsel as a lien.
yeah, lien, sorry.
And I appreciate you're not a lawyer, but you are an expert in real estate. And this is an issue, this is language that comes up all the time in real estate, is it not?
The language with regards to that paragraph?
Well, language with regard to gravámenes and limitaciones de dominio, this is something you see all the time in real estate, in purchase and sale of real estate. Is that correct?
That's correct.
And it also, it goes on to say gravamen o limitación al derecho de dominio. And this morning you gave us your understanding of what that language, limitación al derecho de dominio, was. And now I want to take you to C30.
In this binder?
I don't know whether it's in the binder. Okay, so it's on
Apologies.
screen.
Sorry.
I apologize. That binder was prepared by the respondent. I don't have a binder for you, so I'm relying on documents that are on the record. But you recognize this document, correct?
Yes, I do.
And this is the Otero Palacio title study that the claimants, including you, submitted in this case before us, correct?
That's correct.
Now, if I can take you further down to the similar language, and I apologize, I had it on my screen, but I closed it, so there, paragraph 4. So there you see in 4, the first bullet, we have very similar language. El inmueble, and I'm switching to Spanish, el inmueble se encuentra libre de gravámenes. You've told us those are liens. The translation was accurate as liens. Condiciones resolutorias. Can you give us your understanding of what are those? And again, I don't want a legal explanation, but your understanding as a real estate expert or businessman.
What does the English translation say?
Well, I'll tell you, and these are conditions that would terminate an agreement, such as a purchase and sale agreement. It may be subject to a condition that would put an end to that agreement. And it can be a purchase and sale agreement or other type of agreement dealing with real estate. are you familiar with the term or the concept?
I think I just saw the English version. It said subsequent conditions.
Well, resolutoria, I haven't seen I've relied on the Spanish documents. I haven't seen the English translation, but resolutorio is something that puts an end to. In this case, a condition that would put an end to something, like a contract.
And I greatly apologize. I will have to plead
No need to
ignorance on
apologize.
that.
That's
I honestly don't know,
if you don't know, that's
I don't
fine.
know.
That's
and I'm sorry. And I know a lot about real estate, and I'm not familiar with that
okay.
specific term.
And again, we see ilimitaciones de dominio. So again, do you know what are those?
Limitations to property title. I mean, I think they could be. I think it's speaking in a general sense, and it's saying. I believe what it's saying is any limitations that would, for example, I will throw an example out there that within the chain of title there was a legal representative, or the wrong person signed on title, or there was a legal representative who didn't have you're signing with a counterparty and they didn't have the right to sign because they're the legal representative of the corporation and they only could sign to $1 million and the property's $10 million. Or limitations to domain with respect to, I mean it could be a list of things, I would think.
Okay.
Easements, I don't
Now,
know.
all right, that's fine, and but you also told us earlier this afternoon that almost every document that you received, you turned it over to your attorney, your in-house attorney, and he would know for sure what this language means. Would he not?
My assumption is yes, he's an attorney that understands real estate transactions decently well. He's not a super high level attorney, but he has to be well versed in a little bit of everything: corporate, real estate, employment. It's an in-house counsel that can do the initial things. I would think that he has a decent understanding, yes.
Are you aware, do you know if these categories, gravámenes, condiciones resolutorias y limitaciones de dominio, are regulated in the Colombian Civil Code? Are you aware of whether they are or not?
Working on assumption, I would assume they are,
Okay.
but it's just on assumption.
But your counsel would know.
I would think so, yes.
And when you received this title study and others that contain very similar language, did he advise you on what these categories mean?
No, we never had a discussion about these individual things. If we did, I definitely would have asked what they meant.
Okay.
Exactly.
Okay, fair enough. All right. Thank you, Mr. Seda. Superintendent, that was my question, or my group of questions. I don't have any others. Thank you.
Thank you. And this in-house counsel, is he a Colombian lawyer or a U.S. attorney?
Colombian attorney.
Colombian attorney. Okay. And where is he based? Or she?
In Medellin.
In Medellin. Okay. Follow-up question? All right, this was it. Thank you for your testimony. You are now released, but we understand you will continue to be present during the forthcoming days. Are there any housekeeping matters that we need to discuss? Claimant?
Just a note, nothing by way of ask of the tribunal, but yesterday we did discuss potential new documents by the claimant. We have sent, I think, 5 documents to the respondent. It was very late last night. I don't expect that you will have reviewed them, but I just wanted to alert the tribunal that there are 5 documents. We'll try and resolve it between the parties. Oh, sorry, I'm informed it's about 10 documents.
10 documents, okay.
But hopefully we won't have to trouble the tribunal with it, but I wanted to alert the tribunal to that.
Okay.
But nothing else.
Respondent?
Nothing I say. Thank you, Mr. President.
All right. Then the program tomorrow will include Mr. Hernandez, then Mrs. Ardila, and then Mr. Caro Gomez. That's the program for tomorrow. Just to remind me, will they all testify in Spanish? Yes, all 3 of them. So
Yes, they will, Mr. President.
we will do our best to cover the whole program tomorrow. Counting on the 2 of you there and the translators, the interpreters. Thank you very much. Have a nice evening and see you tomorrow at 9:30.